Hello, my name is Dr. Michael Lane. I'm a lecturer in law at the University of Worcester in the UK. This resource is intended foremost for civil society actors across the globe who have a working knowledge of the Universal Periodic Review, or UPR as we'll be calling it, and wish to engage their representatives in their state's parliament. Now, you may find this video helpful as well if you're an academic or indeed a parliamentarian yourself. Now, the aim of this resource is threefold. First, it's to equip viewers with an understanding of parliaments and their function in the UPR, to explain that there may be barriers or other factors that may prevent Parliament's engagement, and third, to explore some of the practical things that civil society might do to overcome these barriers. Now, the following advice and information are drawn from my research, my practical experience in this area, primarily on the UPR and the United Kingdom. But I also have drawn upon wider research by other scholars in other countries and organisations such as UPR Info. So civil society in all states should find this resource helpful, hopefully. Now let's start, I think, by explaining the role of parliaments and the way that they may contribute to the UPR process. Now, our starting point that we can see here is Human Rights Council Resolution 3529, which, quote, encourages states in accordance with their national legal framework to promote the involvement of parliaments in all stages. And that's my emphasis there. Now, although it will usually be the executive branch of the state that has the primary responsibility for the UPR, parliaments can be involved in the formal process in various ways. They may be invited to contribute to consultations, for instance, held in advance of the state's national report. Or less commonly, parliaments may actually sit as part of the state's delegation at the interactive dialogue in Geneva. But it is important to recognise that Parliament's engagement with the formal UPR processes may be, we'll talk about this, they may be restricted by their state's domestic or constitutional law or parliamentary traditions and conventions. But in any case, parliamentarians become especially important in the follow-up period. So that's after a state's UPR, when the state is expected to implement those recommendations. Here, parliaments can exercise two key functions. So first, they can scrutinise the executive, typically across different forums. This might be in debates, question times, or similar. In thematic debates, parliamentarians might draw attention to a range of UPR matters. So by way of example here, I've taken an example of the UK's third UPR in 2017. You can see that the parliamentarian here, Lord Cashman, raised the UPR in a debate on Brexit, which was the UK's exit from the European Union, and the human rights implications of that exit. One parliamentarian in the House of Lords, drawing attention to what they perceived as a low number of supported recommendations, to suggest that the UK's status, he says, as a human rights leader is at risk. Another example we can see here from Belgium. We see that this is a member of the Senate submitting a question about the executive's failure to submit a voluntary midterm report. So this is Christian Vienne saying, at a parliamentary meeting, I was told that following this report, an interim report was to be drawn up by our country this year, but this had not been done. They're obviously referring here to the interim UPR report, or a midterm report as we typically call it. Has Belgium responded officially as part of this process? If not, could you tell me the reasons? So we can see here the parliamentarians in these two countries using the UPR to inform their scrutiny. The second relevant function parliaments play is the passage of legislation. Now, this will sometimes involve actually initiating legislation, although a parliament's capacity to do that will vary from state to state. So, again, just an anecdotal point, the UK, for instance, Parliament will spend actually most of its time considering bills proposed by the executive, not proposing bills itself. Nevertheless, all parliaments will scrutinise and give assent to bills, and this is most clearly significant for implementing UPR recommendations that require legislation. A clear example, we might refer to those recommendations that call upon the state to ratify a treaty. Now, although ratification is sometimes a power reserved for the executive branch, this isn't always the case. Parliament's consent for ratification is typically needed in monist states, where international law is automatically a part of domestic law post-ratification. An example of a Parliament's legislative function in the UPR is that of the Human Rights and Civil Integration Committee in Georgia, which, quote, follows up on the recommendations received by the state through legislative forums or the passing of laws. Now, at this point, I think we need to mention a particular actor within parliaments, and that is the parliamentary committee. Committees are bodies within parliaments comprising typically a number of members, and they often have the responsibility for scrutinising policy and legislation in certain areas. So you might find that they'll have a committee for justice that will shadow the government's justice ministry. Or you might have thematic committees, so an equalities committee, a committee on prisons, women's rights, whatever it might be. In some states, there's actually a designated human rights committee, which considers the human rights implications of government work across all areas. Where there isn't a designated committee, we say that the human rights would be, quote, mainstreamed. So that basically is just a way of saying that all committees should consider human rights issues in their work. Whatever the situation, though, committees will often have certain powers and responsibilities which make them particularly useful in the context of the UPR. They can typically request written and oral evidence. That might be from civil society organisations, experts, academics. They can hold sessions with government representatives. They can call witnesses. And they'll typically have a mandate to scrutinise policy and propose legislation and produce reports. So with these powers, committees can contribute to the state's UPR in the following ways. First, they can monitor implementation. They could do this, for instance, by seeking evidence about the progress made by the state, asking questions of the government, producing independent reports, these kinds of things. Second, they may take part in the state's consultations held throughout the UPR process. These should be in advance of the drafting of the national report, before responding to recommendations, and then usually, if the state commits to it, in advance of a voluntary midterm report. Third, committees can review the state's UPR reports. Importantly, the working group report that is produced after the state's review and which contains the relevant recommendations, this can actually be really important for scrutinising the executive's decisions to support or note each recommendation. Fourth, committees can attend the UPR review in Geneva, and they seek to speak with states' delegations prior to and after the review. Or less commonly, as already mentioned, representatives from the committee may sit with the state delegation. Whichever way the committee attends, the purpose of this presence is really to ensure that the members of the committee are familiar with the outcome of their state's UPR, but also to maintain that oversight and accountability. Finally, committees can and should work closely with the state's National Mechanism for Implementation, Reporting and Follow-up, or we sometimes abbreviate that to NMIRFs, or just simply national mechanisms. These are focal points within government that have responsibility for overseeing its reporting and implementation for the international human rights framework. Now, these don't exist in all states, but they do appear to be proliferating. Where the state doesn't have a national mechanism, then the committee would still benefit from establishing a relationship with whichever department is responsible for the UPR. So that might be a justice ministry, if there's a human rights department, these kinds of places is where you would expect that to be. So these are the ways in which parliamentarians can be involved in the UPR process, and it's just a summary of what we've talked about the parliamentary committees. Before we move on then to discuss civil society's, I suppose, potential role in best involving their parliamentarians, I think it's useful to recognise that there may actually be factors that prevent these things from happening, these things that we've talked about. Now, this isn't an exhaustive list, and their relevance may vary depending on the state, but the first and most notable is Parliament's lack of knowledge, both of the UPR process and of the specific outcome of the state's UPR. We know from comparative research that parliamentarians can have limited knowledge of these matters. Second, parliamentarians have limited capacity. They must juggle, obviously, the demands of their electorate, their constituents, civil society organisations, and so on. They may not always have the time or the opportunity in Parliament to raise the issues specifically relating to the UPR. Third, parliamentarians may actually be sceptical of the UPR. The UPR is one of many international human rights processes. Of course, we have things like the treaty bodies, the special procedures, there'll be international courts. In Europe, we have the European Court of Human Rights and so on. So parliamentarians may not be immediately receptive to the UPR, or at least convinced of its precise value compared with these other processes. Parliamentarians may even question the very rationale of the UPR. It is a state-led, ultimately political process, and it is, subject to the whims of politicisation. So parliamentarians will think, why should we engage with the UPR? What is in it for us as domestic stakeholders? And we can talk a little bit in a minute about how to navigate that. And then finally, the last barrier to note here is that it's clear that a state's rules, its laws, conventions, its traditions might hinder parliaments from engaging with the UPR in the ways described. A committee, for instance, maybe it's a human rights committee, it might not have the requisite powers or responsibilities to carry out some of these functions we've talked about. Or it may be against a particular conventional tradition for parliamentarians to accompany delegations of the state at international forums, because in many states these international matters are reserved for the executive branch alone. So, with these things in mind, we can now ask, well, how might we better engage parliamentarians with the UPR? And importantly, how can we overcome some of these barriers? Foremost, civil society can lobby parliamentarians, and that is contacting them, essentially with the view of putting the UPR on their agenda. Now, a good starting point would be to identify those parliamentarians that have a personal, or maybe a professional interest in human rights. So consider members of particular committees, for instance. If your state does have a human rights committee, then contacting one of those parliamentarians might be a good starting point. Or you might look to those that regularly raise human rights issues in Parliament. So if you're able to access your parliamentary records, for instance, in the UK we have what's called Hansard, you might have something different in your state, you can check and you can search these records and see, well, actually, which parliamentarians are regularly raising these human rights issues. Again, these are going to be the key people you would want to target. These are people that will, inherently see the desirability of the UPR. And again, much of this information you can find on your Parliament's website. Secondly, when publishing policy reports, responding to calls for evidence raised by parliamentary committees or similar, civil society can ensure that the UPR features in these reports. So as an example, let's say a committee is seeking written evidence on a new bill that maybe it has implications for children's rights. An organisation can refer to the state's UPR recommendations and its responses to those to inform this evidence. It might say, well, the government at the last UPR committed to not doing X, Y and Z when it accepted this particular recommendation. Third, we need to talk about capacity building. Now, as we've already explained, knowledge of the state's UPR, indeed of international human rights more generally, might be a limiting factor for parliamentarians. So civil society can play a key role here in researching and helping parliamentarians to learn about the process. Now, you might do this on an individual level, speaking with members of Parliament, or there may be opportunities to address groups of MPs. Again, the precise nature of these sorts of opportunities will vary from state to state. Fourth, civil society may find benefit in working with their state's national human rights institutions. These are independent bodies responsible for promoting and protecting human rights and perform functions such as advising government, producing reports, engaging with the international mechanisms, and importantly, working to enhance the role of civil society. Now, not all states have national human rights institutions. According to the Global Alliance of NHRIs, there are 118 of these bodies across the world at the time of speaking. But where they do exist, they could help bring civil society and parliaments together. They may be able to provide advice, funding, or platforms to bring these two groups together. To give an anecdotal kind of point here, an example from my own experience, in 2022, working with colleagues from Birmingham City University, we're fortunate to receive funding from the NHRI for England and Wales, the Equality and Human Rights Commission, to work with civil society for the UK's upcoming 4th UPR. And as part of this project, we were able to use this funding and the network we were able to access to give evidence to Parliament's Human Rights Committee. Some, 12 months later, I think it was, that committee drew on our evidence to question the government's Minister for Human Rights on the UPR. Now, of course, again, this is just anecdotal evidence drawn from my personal experience, but it does nevertheless show the opportunities, what may be possible if civil society work with their national human rights institutions to reach Parliament. And finally, civil society should work together to these ends, either informally or as part of some kind of formal coalition. Now, foremost, this could enable precious resources and capacity to be shared. Some of what we've talked about here can take a lot of time and effort. It may not even be successful sometimes. It may even require money to achieve some of these things. But if you work with other organisations, some of these pressures can be managed, they can be shared more effectively. But also you may be able to tap into other organisations' networks. It might be, for instance, that others already have established links with Parliament that you may be able to access. So that really brings us to the end. What can we do to help parliamentarians engage more with the UPR? Lobbying, so speaking to members in Parliament, responding to calls for evidence and incorporating the UPR into those submissions, capacity building. So this is, helping parliamentarians obtain knowledge about their state's UPR, working with your national human rights institution if your state has one. Again, they may have the resources, the advice necessary for your organisation to access Parliament. And finally, work together. Again, this can be a burdensome process. It can take time and effort, sometimes money. Working together can help manage and share those pressures more effectively. So you should now be able to see, hopefully, the role of parliamentarians in the UPR and begin to think about how you or your organisation can feed into this process and to maximise Parliament's engagement. The bottom line, I think, is that civil society need Parliament, but Parliament also needs civil society to bring the UPR to their attention, to help them engage meaningfully with the process, and to facilitate the UPR's aim of improving human rights on the ground. Hopefully this has been a useful resource. Now I've included here some additional resources that you might find useful. This isn't an exhaustive list of all of the information out there about parliaments and the UPR, but it is most of what has informed the information that I've provided to you in this video. If you have any questions, or if you and your organisation need further advice or information, you can see my contact details here, and you can contact me anytime at the University of Worcester at m.lane@walk.ac.uk. Thank you very much.